Capital One Bank.
I put in the opposition.
This was adjourned, we had this about a month ago, and then, Mr. Taylor, allegedly didn't receive notice. However, we did the proper service and then have that hearing, I made it another copy of the motion.
All right, so there's the motion. What do you want to do?
Do you have my reply? Affidavit in opposition?
I've got an affidavit in opposition. And look, it's like, right, so it's dated April 15. The affidavit's got two sentences, but it's got some exhibits. There's the claim, there's an affirmation of service, etc. That's the one you're referring to. I have that.
What date was it filed?
I have the date that it's signed. It looks like April 15th. The file date, April 15th.
Yeah, that's the opposition. Are we on the record, Your Honor? Did I get?
Do you want to do one on this one? Do you want to do one on the record on this one?
I always want to go on the record.
All right.
I wasn't sworn in or anything.
Well, then we'll do that on that. So then we could do is put the oral argument on the record for this, and then if you want, this is the motion and all right. Anything else?
I don't understand. What are you saying?
No, I'm asking counsel here.
Yeah, I'm happy if you want to do a submittal or oral argument, either one.
I'll do a brief argument because I have a trial right now coming up, and it is 11 o'clock. Okay, so we'll do a brief oral argument on this one. Let me get it on the record. All right, we're on the record. This is Judge Peter Lane. April 20th, 2026, recall of calendar number 9. This is Terrell Taylor vs. Capital One Bank, UX number S3-186-254-2. Appearance of counsel, your appearance.
Kennedy Root at Founders Bar for defendant Capital One, 1675 Broadway, 19th floor, New York, New York, 10019.
Okay.
So just raise your right hand. Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Yes.
Name and address?
Terrell Taylor, 174-22, 125th Avenue, Jamaica, New York, 11434.
Okay, so before the court is a motion pursuant to 3211A1, A7, seeking to dismiss with prejudice and notice of claim filed by plaintiff, failure to state a cause of action. So the defendant, briefly give me your argument, and then when you're done, Mr. Taylor, give me his argument.
Thank you, Your Honor. So the complaint we received contains one sentence simply stating money owed for $10,000. There's no notice of the transactions or occurrences. The plaintiff has failed to state a cause of action in direct violation of CPM Law 3013, 3014, and 3211. Previous counsel has discussed with Mr. Taylor, and we've been able to determine that there is an account that Mr. Taylor had with Capital One, but he has not asserted any claim or issue with the account, nor have we found any within our file. There's also potentially been a mention of a car loan.
Who asserted? Was that somebody from Capital One or somebody, another attorney?
Another attorney here who's been, this is the fourth appearance.
Has somebody from Capital One looked at this?
Yes, Your Honor, internally we have looked at it, but frankly there's not enough in the complaint or what we've received from Mr. Taylor to even go to really divest and see if there is an issue. We don't have any issue on file, and he's also mentioned a car loan, which there's no existing car loan with Mr. Taylor with Capital One.
Yeah, this one says, $10,000, January 16, 2025. Excuse me, discrimination and fraud. So fraud, that's
found nothing wrong with Mr. Taylor's account, and he's alleged nothing more than
Alright, so
what's
let's-
in the complaint.
Are you, okay, you done?
I guess.
Ms. Taylor?
Okay, the motion states that plaintiff doesn't state a cause of action. You just stated a cause of action. Discrimination and fraud. Saved a lot of time. So, there's a cause of action. It's for discrimination and fraud. Can you deny this motion and adjourn it for trial? Of course, I don't want to have a trial before you. As we spoke before, there was a lot of complaints against you. And I just came before you like a week ago, or last week or something, and I filed another complaint against you. So, this case is supposed to have been on for trial 2 court dates ago. So I'm just trying to have a bench trial immediately. Once again, you just looked at the statement of claim, right? And it's a part of my affidavit in opposition, but you just looked at the statement of claim and it clearly says, you know, discrimination and fraud. Well, actually, you just state that. So that's the cause of action. It's pretty simple. The cause of action is discrimination and fraud. So everything else the defendant just stated is irrelevant. There's a cause of action for discrimination and fraud. Has nothing to do with investigating the claim and you looked into this, into that. That's not what we're here for. The motion to dismiss is for plaintiff not stating a cause of action. It's clearly a cause of action here. It's for discrimination and fraud.
I'm going to reply, Your Honor.
Briefly.
It still requires plaintiff to set forth particular facts upon which it's claimed, upon which they're requesting relief, as well as setting forth the elements of the cause of action. Simply stating this is a claim for fraud or discrimination is a legal conclusion, and it still gives the defendant no notice of what the actual allegations of the claim of relief is. Therefore, there's no cause of action, and plaintiff's complaint should be dismissed.
Ron, I have a lot of cases. This is the only case where discrimination and fraud is an issue. You know, I have a whole bunch of cases. It's intentional misconduct, fraud, the same claims, no problem. And even if it wasn't, it's not a problem to just put discrimination and fraud. You don't have to go into details on a statement of claim. It's not even enough space to go into details. But I have a lot of other cases where I do the same thing. It's no problem. I even got a judgment on one of my cases.
I object to that.
We wasting time here. Like, there's a cause of action here. Like, please, like, this is annoying. Like, I gotta go. Like, there's a cause of action. I have 50 other cases where I do the same thing. And I went to trial on them already. There was inquest hearings, there was judgments. Like, come on. Like, discrimination and fraud is a cause of action. I just got a case reversed for the same thing, Your Honor.
Objection, Your Honor.
Cause of action is paternal. Like, this is like, come on.
So whatever you want to say is fine.
Quick question, Your Honor. So, aren't you supposed to be deciding on, you know, the motion and the opposition, and you can clearly see that there's a cause of action? So, you know, this is a waste of time. Can you just deny the motion and then we can schedule this for a trial? Like, it's pretty, you know, on its face.
Frankly, Your Honor, we would not even know what is up.
I gave opportunity for, it's in my discretion whether to grant opportunity for oral arguments on a motion or not. Typically, I don't need oral argument because anything you're going to tell me should be in the papers. All right, so I have the papers. I gave you an opportunity for oral argument, and that's now it's done. So I'll mark the motion submitted, and then get a decision.
Hold on, Your Honor.
Thank you, Your
Quick
Honor.
question.
I'm not holding on.
No, I just have a question. So how does this case gets prolonged? Like, the reply is, this is like, I don't care. This case.